Here we are in Module 4 this week, and this module will be the first in a series of modules on cases. So there's a lot to cover with regard to case law and research. So this week we will just be covering some of the basics, a review of authority within a jurisdiction, a new discussion of authority between jurisdictions, and some important things to understand about looking at a single case. And then in the next module, we'll move past a single case and into how to expand into additional cases. So the objectives for this week include understanding the relationship of mandatory authority within and between jurisdictions, understanding that basic three-tiered structure of court systems, applying the principles of authority to select binding cases, understanding the structure and components of a court opinion, knowing how to interpret a case law citation, and understanding the system of court reporters in the United States. It's a lot of things, but they're fairly basic, so I think this is going to be a short module this week. Let's get into our authority review. So we've got 51 bodies of law, right? 50 from the state governments and one federal government. And that's due to federalism. In our system, the federal government can legislate in the areas where it's specifically enumerated, and then the state governments get everything that's not exclusive to the feds. The Supremacy Clause says that federal law will prevail when the state and federal law conflict. So again, this California courts structure, the system has three levels. We've got trial courts called superior courts. There's one in each county. The California Courts of Appeal hear the appeals from the superior courts. They're divided into 6 appellate districts based on geography, and Los Angeles is in that second appellate district. And then the California Supreme Court is the court of last resort, the highest court for California state law. So once again, appeals go up and binding authority comes down. So the superior courts are only binding on the named parties. The courts of appeal are binding on the lower court, regardless of geography. Remember, geography does not matter in California State Court. And the California Supreme Court is going to be binding on all the lower state courts. In the California Courts of Appeals, they can disagree with one another, just like in federal appellate courts. And if there's a split, the superior courts get to pick which decision they want to follow. So that's what this looks like. The Los Angeles Superior Court can choose to follow either the second appellate district or the fifth appellate district if they each have an opinion on the topic. And that's because geography doesn't matter for the authority of California appellate cases. These 6 districts are treated as if they are one single court, and a decision from any one of them is binding on all of the California superior courts. All right, the federal court system, again, 3 levels. This is a review, so just quickly. The trial court is the district courts, the appellate court are the courts of appeal, the 13 circuits, and then SCOTUS. So here we go. Appeals go up and authority goes down. The United States Supreme Court, it's dark red because it's binding on all of the lower federal courts. The courts of appeal is a medium color red because it's only binding on the district courts in its district. Geography matters in the federal courts. So, and then the district courts down here is mostly white because it's only binding on the named parties. All right. So a map of the circuits might be helpful for your authority questions this week on your homework. You can save this map. You can refer back to it in the slides, but you can also always Google circuit courts map, and you'll be able to find this map fairly easily. So we've got our 13 circuits, the 11 numbered circuits, plus the DC circuit and the federal circuit. And it's important because geography matters for authority in the federal appellate court system. All right, I want to mention just briefly the concept of horizontal stare decisis, and I'll use the Ninth Circuit as an example. So how many judges are there in the Ninth Circuit? There's a lot of them. I think there's 29 judges in the Ninth Circuit, but they don't all listen to every case. So they listen to cases in 3-judge panels. So the first 3-judge panel in the Ninth Circuit, no matter where, that decides on a new issue is going to bind all the subsequent 3-judge panels. For example, if a 3-judge panel in the Pasadena courthouse makes a decision on an issue, then all the other courts in the Ninth Circuit, all the other states that fall within the Ninth Circuit, they're all bound by that decision made by that Pasadena 3-judge panel. Now, The United States Supreme Court could, of course, overrule that Ninth Circuit panel, but the Ninth Circuit can also manage that itself by listening to the case en banc. So an en banc panel is 11 of those judges. So an 11-judge en banc panel can overrule a 3-judge panel. Otherwise, that first 3-judge panel to hear the issue is going to bind all the other panels in the Ninth Circuit. Horizontal stare decisis does not exist in California. So the state's courts of appeal here, they can disagree with each other, just like the federal circuits can disagree with each other. But in practice, they're highly deferential. So even though they're not bound by prior appellate court panels, they typically tend to defer when a different one has decided on an issue. So what happens to these lovely rules of authority when we have a state law issue in a federal court or a federal law issue in a state court? We call this cross-jurisdictional authority or crossing the triangles. So we have our federal court triangle and we have our California state court triangle with the superior courts here at the bottom. And what happens when you are here? With a federal court matter. You're in a trial court in the California court system with a federal matter. What type of authority do these 5 other courts have on this court with a federal matter? Is it is it mandatory or persuasive? What opinions are going to be binding on a federal matter here? So let's take a look. If we've got a federal issue in a state court, the only binding authority is the highest federal court, this U.S. Supreme Court. It gets a green box. It's binding down here on the California state trial courts when there's a federal matter at issue. The U.S. Courts of Appeals get a yellow box. They are only persuasive. They're highly persuasive, but that U.S. Supreme Court is the only binding authority in a state court on a federal issue. What happens then if we take that green box away? There's no SCOTUS opinion. But what if there is a Ninth Circuit opinion and a California Courts of Opinion? California Courts of Appeal opinion. And what happens if they come out opposite ways? What's a superior court to do? Do they follow the Ninth Circuit? Do they follow the California Courts of Appeal? There's no SCOTUS, so there's no law of the land. And both of these are persuasive. So since there's no mandatory authority, we're just talking levels of persuasiveness here. And when you're applying federal law in a state court, the interesting thing is that lower courts can follow a higher state court's decision on federal law, even if it differs from the Ninth Circuit. So if these two differ, the California court can choose to follow the California court on a federal law matter, as long as nothing explicitly conflicts with the Supreme Court. So here we've said there's no SCOTUS opinion to conflict with. So this trial court can follow the California Courts of Appeal decision on that federal matter over a Ninth Circuit decision. All right, now we're here, the other triangle. We're here in the federal trial court with a state law matter. What type of authority would the other 5 courts here have on this issue in this court? What opinions are going to be binding and what's going to be persuasive? So the highest court in a state, like the California Supreme Court in our example, has the final say on interpretation of state law. So when a federal court is applying state law, the only binding authority is that high state court. It gets a green box. The exception, of course, is the supremacy clause. So a federal court can say that a state law violates federal law. And in that case, they're not going to follow that state law, obviously. Are there any other exceptions to know about? Well, if the California Supreme Court hasn't decided an issue, if this green box isn't there, then the California Courts of Appeals are presumably binding on federal courts. It gets a yellow box because it's not actually binding. It's just in the absence of this, a federal court is supposed to look to, the next highest state court in the hierarchy. So another what if? What if there's no California Supreme Court opinion, but there's a Ninth Circuit opinion and a California Court of Appeal opinion. And what if they come out in opposite ways? Well, your colors here have a clue. So this one is red. When you're applying state law in a federal court, the lower federal courts will only follow the high state court decisions, not the court right above them. They're not going to follow this on a state court issue. So not the US Courts of Appeal, not even the United States Supreme Court on a state law issue. Interesting, right? So the only one that they follow is the California Supreme Court. So in the absence of that, what happens if we've got a California Courts of Appeal opinion? So this one's yellow. It's not the highest court in the state, but it's treated as presumably binding on federal courts in the absence of that highest court in the state issuing an opinion on the matter. So let's do an exercise. What courts can you cite as mandatory authority? So blue means there is a precedent coming out of that court. So here I've got some precedent coming out of these courts. And gray means the court that you're looking at does not have any decisions coming out of it on the issue that you're researching. So here we've got two blues, First Circuit, Sixth Circuit. And you are here, let's say you're here in the Ninth Circuit, a federal court at a federal matter, and there's no SCOTUS opinion. It's gray, right? So we only have these two opinions to choose from. Are either of them mandatory on the Ninth Circuit? Can you cite either of these as mandatory authority? No, geography matters. These circuit courts can disagree with each other, but they're not binding on each other. So no, there is no mandatory authority here to cite. What if you're down here? Same two opinions are available. You're in a district court. These circuits are technically above you, I guess, in the hierarchy, but no mandatory authority because geography matters. Only if there was a Ninth Circuit opinion would it be mandatory on this district court in the Ninth Circuit. Okay. All right. Now we're still here in the Ninth Circuit, still got a federal matter, but suddenly there's a SCOTUS opinion available. So is that SCOTUS opinion mandatory authority in the Ninth Circuit? Yes, absolutely. Is that Sixth Circuit opinion mandatory? No. All right, we've added another triangle. So here we have a state court applying a federal matter. So we're here in the appellate level of the state court system, applying a federal law. So when a state court applies a federal law, the only binding authority is going to be the federal highest court, the US Supreme Court. So in this image, this SCOTUS opinion is going to be mandatory authority. None of the others are going to be mandatory here, just the SCOTUS opinion. What if we take that away? So in this one, our SCOTUS opinion doesn't exist. We've got a Ninth Circuit opinion, we've got a California Supreme Court opinion, but again, we're applying federal law in this state court. So in the absence of a SCOTUS opinion, we're only dealing with persuasiveness here. Nothing here is mandatory. So the United States Court of Appeals decisions on federal issues are going to be highly persuasive over here in our state court. But also that lower state court can follow a higher state court's decision on federal law, even if it differs from the Ninth Circuit, as long as it doesn't explicitly conflict with the US Supreme Court. All right, we're now ready to try the learning exercise. So get that Word document downloaded, and you're going to begin with part 1, and you're going to stop where it says stop. But here's the analysis that you should be practicing when you fill in this chart. So you'll look at that first case. It's a Second Circuit case, and you'll think about the authority of this case in a federal trial court in Nevada. So is the Second Circuit mandatory or persuasive in the District Court Nevada on a federal matter, right? So they're both federal courts. This one's a district court. This one's a circuit court. But the district court here is in the Ninth Circuit. So is a Second Circuit opinion going to be binding on a trial court in the Ninth Circuit? No, geography matters. What about if it's a California law issue? Is the Second Circuit going to be binding then? Your answer is probably going to be same. So you'd write something like binding on federal law, persuasive on state law, or you'd write persuasive on both, or you'd write binding on both. So this is the kind of thing you're going to be entering into each section of the chart. All right, hopefully this first one is fairly straightforward with the Second Circuit opinion, but it gets more complicated as you make it down further. There's more to analyze. So when you get to this Ninth Circuit court case here, can that bind a Nevada federal trial court on a federal issue? Hopefully you said yes. But what about on a federal, I mean, what about on a California matter? Is the Ninth Circuit ever binding on a state law matter? So you'd write again something like binding on federal law, persuasive on state, if that's the answer that you decide to put in this box. All right, so fill in this chart and stop after that, and I'll see you in the next video.